Thank you. So this is a tribunal of natural justice, and one of the key points about natural justice is transparency. And so we took some time out there because I have a particular issue with two of the names that have come up, which put me probably a bit squarely in the court over there on that side of the court, and may have some evidence that would have been useful to you. So. On the back of that, I'm going to remain on the bench, but I won't be taking a decision as to whether this is prima facie or not.
Thank you, Justice Cleverly. We're now going to go to the final two witnesses and then Michelle.
Good afternoon all. Paul Millinderr. Originally, I've had a varied life in terms of business. I've run online gaming enterprises. I then moved into wind farm development. How I originally became involved in the insolvency business. I was going to build a very big wind turbine at Middlesbrough Football Club's Riverside Stadium. And to cut a long story very short, we haven't got much time, I was very badly stitched up and I was left with no wind turbine. The owners of Middlesbrough Football Club essentially refused the connection after 3 years' work and over £500,000 of money that went into developing the project. And this is how I first became involved with the insolvency sector. And I recognised that there was a big problem in the sector with collusion. Let's not beat around the bush. There is a lot of collusion within the sector. And that led me to want to do something about it. So I set up a private investigation firm called Litigio LLP, in conjunction with a colleague of mine who also owns quite a large firm of private investigators and is a former intelligence officer. So we've been investigating quite a number of various cases within the insolvency sector, Michelle's being one of them. And we have seen common synergy in all of these cases where the vast majority are all founded upon fraud in one form or another. Mine in particular, and mine started off at, apparently I owed them £255,000 in accordance with the contract that I'd actually completed with these people, Middlesbrough Football Club. The trouble that I have with these contracts is I made my contracts conditional, meaning that certain things had to happen before those contracts became valid and came into force in law. And in this particular example, one of them was my full satisfaction of the grid connection agreement. The owners of Middlesbrough Football Club refused that grid connection agreement. So, lo and behold, I didn't really get that much satisfaction of the agreement. And the result is that actually, in law, we cannot possibly owe these people a single penny, but I do have a £10.5 million claim against them. And this is where these individuals have used the insolvency laws to effectively frustrate my position. They unlawfully caused the winding up of my sole purpose vehicle, so I set up a sole purpose company for owning and operating this wind turbine project. They wound the company up for £255,000 that I simply cannot possibly owe. And when the official receiver came involved in September 2016, after they wound the company up, that proof of debt lodged by Middlesbrough Football Club grew from £255,000 to £541,308 within the space of about 6 weeks. Now, given the fact that I know a little bit about wind power generation, that is some generation, but I've got no turbine. So a month later, it was actually the 2nd of February last year, they put in another proof of debt. Only this time, the proof of debt had increased to 4.1 million. And these proofs of debt were all submitted in order to circumvent my rightful position, otherwise as majority creditor, so that I could be prevented from appointing a trustee of my choice, so that I could have place that trustee in funds and action my damages claim against Middlesbrough Football Club. For about a year, I've been asking the official receiver to adjudicate on the proof of debt. I've spent a lot of money on barristers and counsel advising the official receiver that in fact I cannot possibly owe these people any money. And it later became apparent that actually the official receiver had been colluding with the defendants, who I later found they're all connected, they're all interconnected, these parties, and the solicitors representing the football club have a very long established relationship with my friend the official receiver of London. Hence the proof of debt is still there on today's date. But I took the official receiver to court in relation to his conduct, when these official receivers, acting as liquidators, are meant to at all times act in the best interests of legitimate creditors. Well, I'm a legitimate creditor, but he's done everything but act in my interest. So I got very, very unhappy with him over a period of time. I took him into court, and I'm seeking to prosecute him for fraud. Fraud by abusing his position, fraud by acting against my interests and working with the defendants, Middlesbrough Football Club, to essentially uphold these completely random false misrepresentations. I call them what they are, proofs of debt. They are false proofs of debt, so therefore they are fraudulent misrepresentations when the parties clearly did have full knowledge that there is absolutely no way on earth that I could owe them this money. On the contrary, the position is quite the opposite. I have a £10.5 million claim against them for the damages that they cost me resulting from killing my wind turbine project. So that's the background in short on my one. So I took these parties to court, and I witnessed quite a bizarre chain of events in the litigation I've conducted since November of last year. I've been backwards and forwards to court every other week.
Yes.
More or less every other week. And I've seen many of the judges. They all know me on a first-name basis. Whether that's a good thing or not, I don't know. But I've focused particularly on these registrars, these insolvency registrars. I will name them. Chief Registrar Briggs. Chief Registrar Briggs of the Insolvency Court, who I find has a very, very well long-established relationship with the Mr. Hannon, the official receiver of London. And on the night of... So, to cut it long story, I need to condense this, and there's such a lot of information to get out, but I'm going to condense it as follows.
You can submit your paper.
Yeah. So, on the 21st of November last year, I received an unexpected visit by a High Court enforcement officer at my offices in Hanover Street. And this High Court enforcement officer came to recover from me the amount of £619,000. The problem that I have is I don't owe these people any money, and yet this High Court enforcement officer had turned up with a High Court writ of control seeking to levy distress on my goods to the value of £619,000 from Middlesbrough Football Club. Well, I wasn't very pleased about it, and I said, well, I politely told him to go on his way because I don't owe these people any money, and I subsequently, the same day, filed what I would describe as an unwarranted demand with menaces. You do have the High Court enforcement officer seeking to levy distress on my goods to their value, when fundamentally no such order of the court exists. I later found that the order that they sought to rely on was the order that was obtained in fraudulent non-disclosure at the court, whereby on the 6th of January last year, I served a statutory demand on the football club because I was going to wind them up for the abortive costs in the project in the sum of £530,000. So I served my winding up petition on the 6th of January. On the 9th, which was a Friday, on the 9th of January, on the Monday, these guys attend an ex-parte hearing at the Royal Courts of Justice to obtain an injunction, in effect, to prevent me from winding them up. They only obtained the injunction because they withheld over 172 pages of witness exhibits that would have otherwise proven my statutory demand, namely the grid connection agreement. The grid connection agreement that was conditional upon my satisfaction of certain other elements of that agreement. And one of the conditions of the grid connection agreement was that Middlesbrough Football Club took ownership of certain components so that the connection for the wind turbine could be established. Well, they omitted that rather key document from proceedings, whereby that document required signing by the distribution network operator, the people that manage the electricity grid in that locality.
Could you pause for a moment? Could I ask one of the justices to help us all by defining ex parte?
Ex parte means an application before a court without the respondent or defendant being present. It's the sort of application you make when there's a matter of urgency.
But in relation to this specific problem, what it really means is there's no opportunity to challenge falsity.
Yes. Yeah. No opportunity, and usually you only get an ex parte hearing if there is a genuine, urgent reason for it. The reason cannot be, I don't want the defendant here.
Okay, brilliant. Thank you. So, in essence, these 3 proofs of debt that we have are all completely false. So I used the mechanism within the Insolvency Rules 2016 to call upon the official receiver to provide me with copies of those proofs of debt. Rule 14.6 of the Insolvency Rules 2016, which makes a provision for the office holder, upon request of a creditor or indeed the contributory bankruptcy or company member of the company in liquidation, to ask the official receiver or office holder to provide those proofs of debt. Well, funnily enough, when I made the request just after the 9th of January last year, I've still, on today's date, not seen the first and second proof of debt that I requested. But surely the official receiver knows that both the first and second proof of debt are as false as the third in the sum of 4.1 million. So therefore I'm seeking to prosecute Mr. Hannon for fraud by failing to disclose information when required in law to have done so. The official receiver, being an officer of the court, is very well looked after, it would appear, by certain individuals within the insolvency court. In particular, Chief Registrar Briggs, who met with Mr. Hannon on the evening of the 22nd of November at an event organised by Radcliffe Chambers, being the barristers who were acting for Middlesbrough Football Club. So it's very close-knit, far too close-knit for my liking. And yet these judges, these so-called judges, these insolvency registrars, have absolutely done nothing to identify or, to remedy the clear and obvious conflict of interest between these parties. So on the day of the 22nd of November, before Chief Registrar Briggs met with Mr. Hannon and the barrister for the other side, I filed my confidential filings to do with the blackmail, the 619,000 unwarranted demand. And lo and behold, it was Chief Registrar Briggs who approved those confidential filings. And when you make a confidential filing in this court, the judge would have to read, the listings judge at the time, whoever's on at the time, would have to read the confidential filing in order to grant confidential privilege. So therefore my contention is, clearly the judge did know what it was all about, and having read that documentation, on the balance of probabilities, it would be clear that in fact the defendants may well be guilty of blackmail and fraud. I asked for directions on or around the 11th of January this year in relation to the blackmail and the fraud. I asked Registrar Jones, who was the judge sitting on the case at the time, for these particular directions as to what they might want to do about the Section 21 offence, Section 21 of the Theft Act 1968, in relation to blackmail, the unwarranted demand with menaces. The judge avoided the evidence, and he then dismissed my application, which was to remove the 4.1 million fraudulent misrepresentation. And I made that application under Rule 1411 of the Insolvency Rules, which provides a provision in law for the court to effectively adjudicate on these proofs of debt where the office holder has declined to do so. They didn't adjudicate on the proof of debt, even though the proof was blatantly false. They sought to dismiss my application whilst making me personally liable for the costs in his maladministration. That's on to my case. Now I'd like to move on to Michelle's case, which has some striking similarities in relation to the conduct of these office holders and the proofs of debt. I've been investigating Michelle's case, the originating 84.4 K, which Grant Thornton sought to make, or they did make Michelle liable for. The difficulty I have with this is that, same applies, these office holders are at all times meant to act in the interests of, not against the interests of legitimate creditors. Michelle was sitting there as the majority creditor of the Scott Young estate with a £26.6 million judgment order. She was clearly then the majority creditor. In terms of this £84.4 thousand cost, these costs were incurred as a result of Michelle wanting to appoint an alternative trustee to manage the bankruptcy. And at the time that Michelle had made the proof of debt on Q1 2014, Michelle was then majority creditor, and therefore Michelle had sufficient locus by virtue of being majority creditor to have appointed a trustee of her desire. So I contend that the litigation against Michelle is entirely vexatious and is unlawful, because that litigation should never have been commenced by Grant Thornton, because Michelle already had sufficient locus to have appointed a trustee. To follow on from that, I later made another request to Michelle's office holder, who at the time was a trustee by the name of Mr. Allen at FRP Advisory, the trustees acting on Michelle's side.
Grant Thornton appointed a patsy, a bankruptcy trustee of their choice, on this unlawful bankruptcy. So they appointed FRP.
Yes, yeah.
Yeah.
So Grant Thornton, and again, this is, in my opinion, an extremely vexatious and conflicting move, that Grant Thornton, acting as trustees for the other side, who are supposed to be acting in Michelle's interest to recover assets, then bankrupt her unlawfully and appoint a trustee of their making to manage the bankruptcy. It's absolutely insane. So I made another request under Rule 14.6 of the insolvency rules for the office holder. And in fact, I didn't ask Mr. Allen. I went above Mr. Allen and I asked the official receivers directly. I said, I think that there's been some funny business going on here. So therefore, I'm not going to deal with Mr. Allen. I'm going to deal with the insolvency service directly. By which time, having worked my way through the ranks of the insolvency service, they kind of got my measure, and I'm somebody that doesn't really take a lot of nonsense from them. So I got the proofs of debt, didn't I? Within 24 hours, they provided me with all the proofs of debt. And the first proof of debt that came about was a company called, aptly named TIFF Group, TIFF Group, who was supposedly one of the litigation financiers, providing the litigation financing throughout Michelle's family case. When I looked at the proof of debt, it was in the sum of 11.2 million. The proof of debt didn't even have the correct date on it, and neither was it made by the creditor themselves. It was made on behalf of the creditor, and on further investigation I found that the proof of debt was largely false, and neither did it meet the requirements set out in Rule 14.4, which sets out the requirements in law for proof of debt. All of those requirements were missing, so therefore my contention is, at that point, rather than admitting that proof for voting purposes, the office holder should have wholly rejected that proof, because it didn't even meet the requirements set out in 14.4. It was a bad proof of debt. It should have been rejected on those grounds. It wasn't rejected. It was accepted for voting purposes by the official receiver, so that there was a further 11.2 million added against Michelle's bankruptcy. Upon further investigation, I found that no such company exists on the UK Companies Register called TIFF Group. So there's no company in existence called TIFF Group, and therefore there is no proof of debt.
Just a question there. So TIFF Group were the company that was actually putting forward the statement, or were they? You said it was someone who was working on their behalf.
It was done by an agent working on behalf of TIFF Group. TIFF Group have been very silent in the matters.
You say they don't exist, which probably
Well, exactly.
suggestion
They've been completely
of
very
silence.
silent in the matters. But the parties, since I've made the discoveries and made my submissions to the official receiver, not one of them have come forward to say.
Not one of these
actually,
people who don't exist.
Exactly.
Okay.
Not one of them have come forward.
Has the agent come forward at all?
No, nobody's come forward. They've all gone
Did
to
you look
ground.
into the agent, or
They've all gone into hiding.
The only one is the registrar of the court then,
Yes.
who can be identified.
Oh, he can be identified, yes. Yeah.
And the words misfeasance in the public office seem to float through my mind.
Yeah, although I'm looking at conspiring to pervert the course of justice in my particular case, which involves the same registrars.
there's a run of similar fact.
Yes, yeah. And
Have you acquired more? I mean, obviously two is more than enough. One would be enough in any instance. But is there more than two of you?
Oh,
cases
yes,
like
yes,
this.
oh yes, yeah. I'm working on half a dozen or more. In fact, we've got more that I've not finished investigating. I'm working on half a dozen substantive cases that all share this common synergy in that all of these bankruptcies have fundamentally been founded by fraud in one form or the other.
And involve common individuals.
Yes.
Thank you very much.
Unless you have something really trenchant to add, I think you've painted a picture. Do you have something you'd like to do?
I think that's everything.
Is this a
Robert,
good point
thank
to
you.
stop? All right,
Yes,
I
thank
think
you.
you've done marvelously.
What became of the 11.2 or 11.1
Well,
million?
that's good.
When you said that there does not exist such
Yeah.
company.
I've asked the trustee, Mr. Allen of FRP, to come forward and provide his commentary on why this has been accepted, and he hasn't done. He's actually gone to ground on me, and he's failed to provide other information that we've asked for, that he would be required in law to have provided to us. So what I have done, and one more submission if I may, what I'm going to submit is the fact that I've now submitted a proof of debt to the official receiver of Scott Young in the sum of 751 million, being the value of the estate that Michelle is entitled to.
Let's stop there, but I have one question
this
after
question
Justice
there.
Cleverly.
When did you write to? You referred to someone just now that was. When did you write to them?
I wrote to Paul Allen of FRP about 6 weeks ago or thereabouts, before we conducted our dawn raid on his office. And since then, unsurprisingly, he seems to have gone to ground on us.
Is there no legal way to compel him to respond by date certain?
I'm taking legal action against him, but I'm going down the fraud and the misconduct route to deal with him.
I've said to Paul, I don't want to take any legal action in any court in this country because there is no such thing as justice. So I've said to Paul, until this is addressed publicly, I refuse to go into British courts.
I just have a couple of questions. My brother Justice referred to similar facts. It's a legal expression where normally you can't allege a previous impropriety, but if there are similar facts you can, and say this is a pattern of behaviour, and that compounds the complaint that you could make. I'm curious, the $84,000 debt, was it ever shown how they made that sum up?
It started at 20,000, and they're all, in my opinion, they're all disproportionately inflated costs.
Right.
Costs that should never have been Michelle's costs. They were costs that fundamentally belong to the Scott Young estate.
Yes.
They're not Michelle's costs.
Yes. That I found curious, and as I said, I know you said you could name names, but one name we do know. I mean, we've got the name of the Deputy Registrar, and if you do want to, I know Michelle doesn't want to take action in a British court, but a British court might be very interested in misfeasance in a public office.
Yes.
And a term in jail is actually good for your health because you don't eat as much and you don't get any alcohol. So
I mean, the 84,000 was actually Those fees were racked up by them denying my legal rights to a creditor's meeting as a judgment creditor for 26.6 million. That's how unlawful this is. They denied my legal rights to a creditor's meeting.
Thank you very much. I know that there will be another opportunity.
We are the power behind the ITNJ. Add your voice. Sign the treaty.